Today we're going to talk about trust and things you thought you knew about trust and things that maybe aren't true. Before we start, as I said last week, I want to make sure that I'm clear with you all that I'm not giving you legal advice today. I'm giving you legal information, and there's an important distinction. Information is just bare facts. Advice takes that information, applies it to a various nuanced fact situation and helps you arrive at a course of action. So this is just information to help you understand the process and the things you might need to do. And you need to be clear that since I'm giving you information, I'm not your lawyer. So I'm happy to become your lawyer, but that takes a specific agreement between you and me, more specific than just this Zoom meeting. We're going to post this on the Facebook page and on the website so that you can send others to, you may send others to come back and look at it later. And I welcome any follow-up questions that you might have to send to me. So with that housekeeping bit, I'm going to start off here with some of the things that people have said to me. I get so much of people asserting this is a fact. Only wealthy people need trust. I'm not wealthy, so I don't need a trust. If I put my house in a trust, then it's going to be protected from creditors, and I want a trust so I can hide all my assets from creditors. Or how about my neighbor, or fill in the blank, my coworker, my cousin, told me that I need a trust because it's better than a will, and I have to have one, and I'm not clear on what I need or why I need it, but my cousin said it, so I need it. It's cool. And then so much confusion about taxes. How many times have I heard somebody say, I can only give away $15,000 and I can't give any more than that, and I have given that, so I can't give this away. Well, we'll talk about taxes in a minute. All of those things that I've just told you are wrong. And so I want to talk to you about what a trust is, how you use it, why you might want it, and what the reality is. So first, we need to understand what a trust is. A will is a document. A will is a piece of paper, and until you die, it's nothing but a piece of paper. It doesn't give anybody any rights, and it really is not a crucial thing while you're living. A trust, on the other hand, is not the document itself. It's a relationship. You can have a trust without a piece of paper. You can have a trust that's part of your will. You can have a trust that's on another piece of paper that exists during your lifetime. So what a trust really is somebody giving an asset to somebody whose name is the trustee, giving them instructions on how to hold this asset for the benefit of a third party or parties that is the beneficiary. So whenever you have a relationship between a grantor or a creator of the trust, a trustee who is managing and handling the assets, and the number of beneficiaries, that relationship is what creates the trust, and that's why we call it a trust. And you're trusting people. But the most common one is a living trust. And the difference between a testamentary trust and a living trust is simply that one's in your will and one is created during your lifetime. Now, my preference is to use living trust because they exist now, and you can get things up and underway and start the process while you're living. And there's a lot of applications that we'll come back to. But just understand that the trust is the relationship, and that the person creating it decides what is going to be in the trust and what the instructions are going to be. Okay, so why would you want to trust? Why do you use it? What good are they? Well, the first and most common and most important reason for having trust is to set up a system so that one person, the trustee, can manage assets for one or more other people who would be the beneficiaries. The most common of these is when you have young children. So if you have young children, you want to set up a trust so that someone can manage the money that you have set aside to take care of your children while they're young if you're not around to do it yourself. So that would be a trust for young dependents. But it could be a disabled relative. It could be elderly parents. It could be yourself when you know you are facing a period of disability. So elderly people frequently create trusts and want to have the money in the trust managed by a trusted relative, perhaps a child, in the case of them becoming elderly and unable to manage their own assets. So that's the most common reason and the most, to me, substantial reason for using a trust is this strategy of one person manages, another person benefits. You might also have the goal to avoid probate and keep assets private, keep affairs private. For instance, if you had a testamentary trust, all the provisions about what your children get and how they're managed and when they get it, all of those things would be out in the public record for any nosy barker to go downtown and read the will in the courthouse. But if you put it in a trust, it's private. The only people who have a right to see what's in a trust are the settlor, the trustee, and the beneficiaries. Now, if you've got conflict within the family, it behooves you to be very mindful of whether you want to allow someone to come nosing around. So you may have someone that you might want to have be a beneficiary, but they may not be as stable as you wish, and so you may want to consider that you might want to set up a system where the person that might create a conflict has a separate trust with separate things set up for that particular person, so that they cannot go create a fuss with the other beneficiary. So some of that you need to think about a little bit, and if you have those issues, you need to get some good advice about how you're going to set that up. But that would be a way of keeping it private. It would be a way of avoiding probate. It's not the only way to avoid probate. We used to use these trusts for tax planning, but with the new statutes on taxes, that's really not applicable to the ordinary mom and pop folk. So we'll come back and talk about taxes later. Every once in a while, you also want to use this to avoid creditors or to qualify for government benefits. And this flips into my next topic, which is what happens when you put things into a trust, and why would you want to put things into a trust? So let's look at that common misconception about if I put something in a trust, I can avoid creditors. Well, what about revocable? Don't you understand? As long as it's revocable, you can control it. And if you can control it, your creditors can get to it. So this does not protect you from your creditors. It just doesn't work that way. But what if you have a child who is just a spendthrift, or a child who is disabled and can't manage money, and you want to keep these young people protected financially by providing a sheltered pool of assets? Well, we can do that. It is not something that you do lightly without careful thought, but you want to try it. So if you're going to have a special needs trust for a disabled child, then we have to have very specific, carefully drafted provisions that define what that beneficiary can have, and it's limited. This is not a silver bullet that will solve all the problems for a disabled adult. That's for a whole other long discussion on another day. But you can provide a little nest egg here for a few things. And if you have a child who really can't handle money, is prone to either gambling or some other addiction, or has just poor judgment, you can set this up and specify that creditors can't come after this money, that it's totally within the control of the trustee to decide when the beneficiary gets it and what they get it for. So that would be one of the results of putting money into a trust, is that you might, once it becomes irrevocable and your beneficiaries are getting it and you're gone, then you might be able to set up some protections, not just taking care of young children who are legally unable to handle it, but protections. One of the reasons that we set up a trust for elderly folk is to think about how can we use this to qualify the person for Medicaid benefits. You have someone who has to be disabled, elderly, and has to be poor. And if you have money in a trust that's used for very limited purposes, there's some application there too. So I guess the point here, the takeaway, is that a trust is a very, very flexible tool. It can do lots and lots of different things. And if you have a problem that you want specific help with, then a trust might work for you. You shouldn't go into it saying, oh yeah, this would be cool. My friend has one, so I'm sure this is going to work. You need to start with your specific issue and think about how you're going to solve it. So if you see that your neighbor has a trust, you don't know that that means you have a trust or should have a trust, okay? It means that their lawyer has looked at their situation and their goals and has decided that that's one way to resolve the problem. You need to think about how are you going to define what your goals are, and start with your goals and not with, yeah, trust is a really cool thing. So you want to be very clear about where you're going and what you want, and not be trying to micromanage or be as cool as the neighbors, or be really smart. Now, I want to flip over And I'm peeking on the side here in case there's any questions on the chat, and I'm not seeing any that have been typed onto the chat, but you feel free to type one on the chat if you want to ask me something. But I'm going to flip over here for a minute and talk about taxes, because this is something that we hear a lot about with trusts. First of all, there's this prevalent conception that $15,000 is the limit. I hear it from accountants who know taxes. Yeah, $15,000 is the limit. Well, what $15,000 is the annual limit of the amount that you can give to any individual, and you can give as many as you want to. So you can give dozens of $15,000 every year. And what that does is that exempts that number from your gift tax return. But the government doesn't want you to pay taxes on gifts until you've given away $1 million over and above the $15,000. So if you're not giving $1 million to anybody during your lifetime, well, it doesn't matter. So don't worry about it. Okay? Gift taxes really are not a very big thing in our daily lives. So don't worry about giving away $15,000. And really, unless you have, 10 million, don't worry about estate taxes. If you're under 10 million, we don't even need to talk about it. And if you get over that, then we need to be a little clever, but not a big deal. So estate taxes and gift taxes, those aren't our deal here. As far as what you need to be aware of, the big thing is income taxes. Now, most people are aware of the fact that when you sell a house, you don't have to pay capital gains tax on that house because it's your home. And when you sell stock, you have to pay capital gains tax on that because that's just what the government does. They charge capital gains tax on everything but your home. So that's where you start with on income tax is mama has a bunch of stock and it's highly appreciated. Hang on to it. Don't sell it. Because if mama still owns that stock when she dies and all of her children inherit it, they get a new basis. If you own it when you die and your children inherit it, or anybody else for that matter, they get a stepped up basis. So your children's basis in that stock is equal to the value on the day mama died. That's huge. If mama has owned 42 shares of Johnson & Johnson since 1958, there's a lot of capital gains sitting there waiting for the government to collect taxes when she sells it. But if she passes it on to you, unsold, in kind, and you collect it as stock, all the tax that mama would have paid is never going to be taxed. It's never going to be collected. It's gone, done, and over there. That's an important piece of information for estate planning. You have to think about that when you're elderly and you're thinking about what you keep and what you sell and how you pay for the nursing home. You have to understand income tax to do a good job on estate planning. So if the stock is inherited, it gets a step up in basis. Now let's go back and look at mama's home that she's lived in for 40 years. I have a lot of old mamas come into me. I want to get rid of this house. I want to deed it over to my son. I'm tired of worrying about it. I don't want to fuss with it. Deed it to my son. And I say, no. Let's not do that. Let's not be hasty. Because if mama owns the house, if she sells it, there's no capital gains because it's her home and there's an exemption there under the rules. If she owns it, she dies and her son inherits that house, then he gets that stepped up basis I was telling you about. So he can sell it after mama's gone and he doesn't have capital gains tax to pay because his measurement for how much tax he owes is the value on the day that mama died and the increase till the day he sold it, which might be 59 cents. So you need to understand that. And then the other piece you need to understand is that if mama actually did give it to him during her lifetime and he never moved in and lived in it, and then he sells it, he gets her basis, but he doesn't get her capital gains exemption for selling your home. So you've got the worst of all possible worlds there if she deeds it straight out to her children, because they don't get the capital gains exemption for your home and they don't get the step up in basis. So again, this takes using this knowledge and applying it with careful strategy to be smart about how you handle this plan. So if we think mama's going to need to go into a nursing home and we think we're going to need to sell this house to pay for the nursing home, mama needs to sell it. And she ain't going to want to, but if you're going to do it in mama's name. Don't deed it over to the son and then let him sell it later. If you're going to keep it, then you have some even more tricky strategy tax planning to do. You can deed the house to the son and say, you can deed the house to the son and say, I reserve a life estate. If you have a trust, you can deed the house into the trust, and either way, you've avoided probate. So that's a good thing. Remember, that was one of the purposes that we said we had for a trust, was to avoid probate. But if all you've got is a house, you don't really need a trust for that, because you can say, I'm doing a deed for this house, I'm giving it to my son, but I'm reserving a life estate, and then he inherits it by means of the deed, not by means of the trust, and he gets that stepped up basis we talked about. But this normal revocable living trust does not qualify her for Medicaid, so it may not be the best choice if she might need Medicaid. So think about that though. Let's assume that we've decided, okay, we're going to deed this house over to my baby boy, and I'm going to reserve a life estate, but then I have to go live in a nursing home. Well, what are we going to do now? The big problem is, how are we going to pay the taxes, the insurance, the utilities? How are we going to keep this house up? Well, mama's in the nursing home. All her money is going to go to pay the nursing home. Now, if you can rent the house out and make enough money to pay for the nursing home, well, you're golden. That's one possible strategy. But if you don't, and you need the money from all of her income to pay her nursing home, and then you have this house sitting here, you're going to have to find a cousin or somebody to move into it, not pay rent, and just keep it up and pay the taxes and the insurance. So there is no simple, easy answer when you're trying to qualify somebody for a nursing home, but you need to understand all these complex income tax questions. So for the ordinary family, gift tax is not a problem, so don't worry about the $15,000. Estate tax is not a problem because most of us don't have $10 million to plan with. It's income tax we need to think about. If you have a bunch of income producing property, that is in the trust, you need to understand how the income tax is going to play out there. And that will most likely be taxed to mama because she is the one that created the trust. She is the one that controls it. And the IRS is going to ignore this whole trust as if it was never done because she is in charge of everything. So the point of all this is that there's no simple answer to taxes, but it's crucial that you know that it's income tax you need to be looking at. You need to be holding hands with the accountant and talking to the accountant about a good plan here. And then you need to just not worry about what you give away unless you're going to qualify for Medicaid, and then that's a whole other thing we'll talk about on another week. So, trusts are useful tools, but don't just go get one just because you think it's cool. They're cool, but they're not cool if you have one because you think it's cool and not because you need it. I welcome any questions that you may have. I have not seen any questions on my chat group here. So if anybody wants to chime in and type a question, I'm looking at the bar and don't see any. I welcome you to email me or send me a private message on Facebook. And I'm happy to hear from you with follow-up questions. And I hope this has been helpful. We are recording it and we will post it in due time onto the website and onto the Facebook page. And this will be available for you to refer other people to. So come back and see us in what are we doing? 3 weeks, I think it is, for the next one. And the next time we're going to come back, we're going to talk about powers of attorney, living wills, and all that healthcare and financial deciding business. So, but that's it for today, and look forward to hearing from you later.